Hi, this is Rahul Reddy. We're live here from Houston, Texas. Along with me is my business partner, REDDY NEUMANN. We're here to discuss live question and answers as we come every Tuesday at 5 p.m. Central Time. Emily.
Thanks for joining us today. I hope everyone had a great Thanksgiving weekend and got to enjoy some time off. Today we're going to be talking about H-1B adjudication issues, increases in denials, types of requests for evidence, as well as F1 student visa issues regarding OPT, STEM OPT, and CPT. Just kind of an overview of what's been happening in employment-based immigration for the last 12 months or so, how things have changed, and what to expect going forward.
I mean, CPT has become a major issue with a lot of H-1Bs coming into the lottery system, which didn't used to be there before. I mean, the lottery system has been developed in the past 5-6 years. We've been having the lottery system. People are unable to get into the H-1B, and they're choosing to do day one CPTs. Some of the universities are giving day one CPTs on the day one you join the university. Do you think so it's legal to join these universities and work on day one CPTs?
I think that in 99% of the situations where we see it happening in, it is not authorized. And the reason for that, there's kind of two parts to it. The typical situation where someone is enrolling in immediate CPT is after they've already completed a master's degree, then they've used up 12 months of their regular OPT and used up 24 months of their STEM OPT, and then they're going to school for yet another master's degree and working using this CPT. Now, the way USCIS is interpreting the regulations, they're saying that in order to get more practical training, you have to go up a degree level. So it's a problem that people are issuing this CPT at the same degree level, at the same master's level they were in before. That's one aspect that makes it unauthorized. On top of that, there are supposed to be limited circumstances in which CPT can be authorized during your first year of graduate studies. Normally you have to be in school for at least 1 year before CPT can be authorized. Now there's an exception to that rule if your program requires immediate participation as part of its graduation requirements. Those types of programs are pretty limited in the general education community. So I think that some schools may be taking advantage of that exception, using it as a loophole to allow people to work and study on the side, which is not what the F1 is for. The F1 is for studying and then maybe getting some practical training work during a short-term internship or OPT after you graduate, but it's not meant to provide full-time employment. And that's another issue. CPT and OPT during the school year is supposed to only be authorized for 20 hours per week. That's considered full-time employment. Yet these schools are letting people work 40 hours a week and then go to school on the side. For those reasons, I think it's not authorized, and USCIS is agreeing with me. Really, it's the other way around. USCIS thinks it's not authorized, and because of that, we're trying to let people know not to fall for that trap, because we're the ones that see these denials come in, and we want to make sure that others are not impacted by making that same mistake.
So, Emily, when thousands and thousands of people are going to this day one CPT, you're just telling that it's not legal. I mean, how come these universities are issuing day one CPTs? What kind of, what do you comment about the universities that are issuing day one CPTs?
Well, I think that they're issuing it because the SEVIS system allows them to, but that doesn't mean it's proper. And these universities might be taking advantage of students that are in a tough situation and looking for any way out. And I understand you get desperate in that situation, but desperate often leads to stupid plans, and I think some of these schools are taking advantage of that.
And these schools we're addressing about from the beginning, we've been telling, they are not conducting any class assembly. If ever they're conducting, they're only conducting classes once in a month, or some of these universities are conducting one class in the entire semester. And that wonders that what kind of university these are. Are they actually schools, proper schools, or these people are just issuing an employment authorization documents for the people who are not eligible for just because they found it's not a loophole, I think, so it's kind of illegal activity according to me. It's not something that legally it's allowed there and they're doing it. They're actually crossing the line when they're doing the CPT. Now, coming to the point, what difficulties that you are saying that the USCIS is kind of now denying the H-1Bs when people are filing from day one CPTs. Can you explain what you're speaking about? And can you explain what the consequences would be? Can you also see what are the remedial measures that the students need to take?
So typically we see this come up most commonly in a request for evidence on a change of status from F1 to H-1B. So anytime you're filing a request for a change of status or an extension of stay, you always have to document that you've maintained your prior status up to the time of filing. And so when USCIS sees that someone has been in F1 status for years and years and has, all of their OPT cards, and now they have these I-20s showing that they're engaged in CPT, we often get requests for evidence asking for proof of maintenance of status during F1 time. They'll ask about how was the CPT authorized. They'll quote the regulation that it says that you can't have additional practical training time at the same degree level and ask how you qualify for it, which there's no answer to that. I mean, other than arguing that they're interpreting the regulation wrongly or differently. So they used to interpret it differently, but they've changed that interpretation. So unless you're going to convince the officer that this new interpretation is not correct, we're seeing denials in almost every case. I've seen very few.
Does the denial has any other negative consequences other than the H-1B getting denied?
Well, the H-1B petition itself isn't typically denied due to a status violation, but the change of status portion is denied. Now, that means once you have that change of status denied, if it's on the basis of a status violation, now we have to worry about the August 9th memo on unlawful presence for F1 students. That is when that memo kicks in. And it says that when a change of status is denied due to a status violation, the person will be considered unlawfully present from the day the violation began. So for these CPT people, if they've been doing this for multiple semesters, the day the violation began is the day the memo took place, starting August 9th. So when an H-1B change of status gets denied due to a status violation caused by unauthorized CPT, the individual is considered to be unlawfully present from August 9th, even if the decision comes in December or January or February. Now, if that decision comes in February and it's determined that you've been unlawfully present from August 9th, you have now been unlawfully present for over 180 days. Once you cross 180 days of unlawful presence, the only way to get back in status is to exit the country. But when you exit the country, you're going to trigger a 3-year bar to coming back, meaning that H-1B approval that you just got is now useless because you can't get back into the country. Even you're not going to be able to get the stamp. You're inadmissible to the United States. And I think a lot of people don't realize the effect, the combination
because
of
it hasn't
these,
been February 4th yet.
The combination of these denials of change of status and this August 9th memo once you reach 180 days, because I mean the unlawful presence of 180 days triggering the 3-year bar has been there since 1997.
Mm-hmm. April 1st, 1997.
You never
That's
hear
when our
about
office was
it
formed, yeah.
in employment-based cases because no one ever crosses 180 days of unlawful presence. But now, because of this August 9th memo, you may be unlawfully present without even realizing it and cross 180 days, and then you're stuck. There's no going back at that point. You can't undo it. You can't. And a lot of people ask me, well, if I just stop doing CPT now, does that solve anything? And no, it doesn't. Once you've violated your status, it's not possible to get back into status by stopping the violation. Stopping the violation doesn't cure a prior violation. The only way to properly cure it for F1 students is to terminate your current SEVIS record, apply for a new SEVIS, pay the new SEVIS fee, go
Leave.
outside the country, and come back in new F1 status.
And all of that before February 4th. If ever anything, you leave the country after February 4th, you still will be barred for 3 years. Now, next year, the same thing will be applicable in a 10-year bar situation. So if anybody is on day one CPT, our advice right now is immediately contact a lawyer because you will be in great trouble. Now, we have been advising people many times before from the beginning, since the time the August memo, even before that too, that this day one CPTs are not legal. See, the August 9th memo is effective on August 9th. It was published way before. From that time, we've been warning people the day one CPTs will be in great trouble. If you are on day one CPT, we would advise you to contact a lawyer immediately. Please also notice that there are only 4 or 5 universities out of the 3,000 education institutions, approximately 2,500 of them allowed to issue an I-20. Only 4 or 5 universities are issuing the day one CPTs. Not only that, these universities are not conducting any classes. They are not conducting any classes. They're conducting once a month, some of the universities once a semester. So that these universities have a trend. Previous to this, there are a couple of universities that got into trouble. We are expecting that these universities are also going to go. When they go, you're all going to go down. So if you are on day one CPT, contact a lawyer immediately. Emily, have you seen any new trends in the immigration since this administration has come in? I've been practicing immigration law from 1995. I'm a lawyer. From 1997, we established our law firm from April 1st. It's unprecedented that I've seen the amount of denials. The amount of denials that I've seen in the past 2 years is more than 3 or 4 times what I have seen in the past 21 years. Before the 2017, I've been practicing 21 years before that. Whatever I've seen in 21 years, I've seen more denials. What do you feel about this administration going forward? What do you expect? And what are the precautionary methods that they need to take?
Well, I think that the Buy American, Hire American executive order kind of set the tone for what to expect in immigration from this administration. They certainly want companies to focus on hiring American workers, not foreign workers. And in order to, put that into place, they're making it more difficult for businesses to get approvals of visas for foreign workers. Now, how can you do that without any changes in the law? They've done quite a few things. Just how they're interpreting what is a specialty occupation. They've raised the bar on what it takes to prove specialty occupation. They're looking at your prior maintenance of status much more than ever before. We have the RFE memo that says that if you're missing required initial evidence that they're not going to issue an RFE, they'll issue a straight denial. We have the NTA memo, which now says they're going to put people into removal proceedings at the time of a denial if their I-94 is already expired. Then we had the computer programmer memo that said computer programmers really aren't specialty occupations anymore.
System analyst denials.
Yeah, we started seeing level 1 wage
denials
issues in the RFEs, and then systems analysts, financial analysts, market research analysts.
Specialty occupation,
all of those are
right
being
to control
questioned.
issues. A host of different things though. So at this point of time, if you are contemplating to file H-1B in April 2019, we strongly recommend that you hire a law firm which is very good in dealing these things. They deal in every day in these things, and make sure that they are well versed in the immigration current knowledge. I mean, if you've been filing once in a while, they cannot do that. So be careful on those things. Also, for those people who are in STEM extension, you need to make sure that you and your employer are complying with the 983 form that you have submitted to the school. You have the proper updates that were being done. Reviews are being updated into the system. Otherwise, you may get the change of status denial, and the same things what may be applicable for day one CPT and what Emily was describing about the August 9th memo may be applicable most probably for your STEM extension to H-1B denial too. So you need to be careful about that. Now, we do have the premium processing suspension at this point of time, except in the cases for the extension cases. We are hoping that the premium processing will be ban will be lifted in February of 2019. For those cases that are getting filed right now, which either is an amendment plus extension, amendment, or transfer of the H-1B case, you can later on convert that when the premium processing open. If you file in the normal processing, you can convert into premium processing at a later date. So you may want to also look into that. Any other current updates, Sandy, that you want to do? H-4 EAD, anything you have seen it?
Nothing new there. I didn't check it this week, but as of last week, nothing has been submitted to OMB on that yet, which means that if there's going to be something, it won't be until probably the last week of December at the earliest.
For those people whose priority date is current for EB3, but not EB, for the priority date is current for EB3, but you have an EB2 approval, you may want to check with your lawyer to convert into EB3. There are provisions where you can file an I-140 using the same old labor certification, and you can file the adjustment of status at the same time. So you can look into that if your priority date might be current in EB3, but is not current in EB2. This kind of situation occurs very often for Chinese nationals, but it started happening to Indian nationals. Going forward, it seems to be that EB2 and EB3 for Indian nationals is going to move at the same level, at or about the same level. I mean, let's go to some of the questions that are there. Is premium processing allowed for I-140 right now, and do you advise premium processing for I-140?
Yes, it is, and really it depends on the situation. In most cases, premium processing probably isn't necessary for an I-140 unless you're getting close to your 6-year limit on H1 and need the I-140 approval to extend your H1, or some other, or just for peace of mind to get it over with, but it's not as necessary to do the I-140 and premium processing. Processing times are maybe 4 to 6 months right now without an RFE. Not too bad.
From YouTube, Mehul asked this question, Emily, is that can you describe why the USCIS is issuing the short-term H-1B approvals when the employer is requesting for 3 years and they're only giving 3 months, 2 months, sometimes 10 days? Why is that? How we can prevent those things if possible?
Well, it's this idea of speculative employment. USCIS wants to make sure that when you're requesting a 3-year extension, that the company can document that it has 3 years of work available. So typically where we see this is in the consulting industry, where you're placed at a third-party site and you have contracts and work orders between multiple companies, where especially the work order issued by the end client is often short-term, maybe 3 months, maybe 6 months, based on what their budget process is and how often they're planning to renew. It's just standard business practice to issue these short-term work orders and continue to review or renew them. But USCIS doesn't look at those as proof that they will be continued to renew. They just look at, you have 1 3-month work order, therefore we're going to give you only a 3-month extension. There is a lawsuit that's been filed on that exact issue, arguing that it's not within USCIS's authority to give a shorter approval notice based on speculative employment, that it's actually the Department of Labor's job to monitor, to make sure that H-1B workers are not benched without pay and without work while they're here. So we'll have to keep an eye on that litigation, but there's not really a whole lot that you can do to get around it. I mean, if the work orders are short, maybe you've been on that project for some time, you could show that you've got the past work orders and you have a history of them always being renewed. That can sometimes help, or depending on the language in the end client letter, what they say about the length of the expected project can help sometimes, but usually USCIS is going with whatever is the shortest duration on the document submitted.
Two of the people have the question, Rippy and my HDTV have the question. My priority date is not current under EB3 right now. can I or should I convert into EB3? I have an so this gentleman has an EB2 approval. His priority date is not current in EB2, neither it's current in EB3. Since the priority date for EB3 is a little bit more forward than EB2, is this a right time to convert into EB3? I don't think so. At this point of time, it is justified the expenditure that is involved in converting EB2 into EB3, since it's not current for you at this point of time. Now, when and it becomes current, you don't need to have an I-140 approval to file an adjustment of status for you. If you file an I-140, if the priority date is current under EB2, you're filing in conversion from EB2 to EB3, you can use most probably the same labor certification for EB2 and you can file an EB3. At the same time, when you file an EB3, you can file an adjustment of status. So if the priority date is not current right now under EB3, I'm not sure if I would be filing under EB3. I'll file a EB3 I-140 at this point of time. Now, if it is current, though, it's a different status. If it's not current, I wouldn't recommend filing at this point of time.
Vanilla has a question on Facebook. She currently has a pending H-1B waiting for the approval and is thinking of changing employers.
Is it a quota?
That's the question. So is now the right time, or do you have to wait for the approval? Depends on quite a few factors. The first factor is what exactly is pending. Is it an extension? Has your I-94 already expired? Is it a different transfer? Or is it a cap subject case? If it's a cap subject H-1B, you have to wait for the approval to be considered counted in the cap in order to have an H-1B to transfer to another employer. If you have a pending extension, it really depends on whether your I-94 has expired or not and whether it's safe to transfer in that situation. If it's another transfer that's pending, that can also be risky because when you leave employer 1 to join employer 2, employer 1 may withdraw their pending H-1B, and that withdrawal could be causing the bridge to collapse between your old status and your new transfer, and that might put you out of status as well. So definitely speak to an attorney before you consider filing a transfer to a new employer when you're in that situation.
We request those people who are putting questions in either Facebook or YouTube to clear questions when they are, is it applicable? Not just the extension is pending. You need to mention whether your I-94 is there. Please be very specific, though. Otherwise, it's very hard. There's a question that's coming from Santosh is that how long it's going to take for the H-4 EAD approval. I mean, is it filed along with the H-1B? Is it filed along with the H-4? It's filed alone, so that kind of, if you give it more clarification, we would be able to answer it much better. In your case, if you just file the H-4 EAD only, it's taking approximately 90 to 110 days. If we file along with the H-4, not with the H-1B, then it's taking approximately anywhere between 6 months to 1 year to get the EAD approval. If you file along with the H-1B, H-4 plus EAD, normally it will be adjudicated along with the H-1B application. That depends on the premium processing. But we appreciate, guys, if you can give a little bit more specific questions, that will be much better for us.
All right, Surjit has a question. Why is it taking so long for H-1B extensions applied in June and still waiting? What's going on with premium? Yeah, it's taking a long time. I think it depends on the service center. I think that, number one, if it's just a plain old extension and it's filed in Nebraska, those can still be filed in premium processing, so there's no need to wait on that. And even without premium processing, those are not taking too long to process. In other service centers, I think honestly that since the Simeo decision came out requiring amendments to be filed,
from the change of location?
Yeah, that really created a huge backlog because for one H-1B that was valid for 3 years, now all of a sudden you're filing an amendment every year, and now on top of that we have these shortened approvals. If you're going to approve my H-1B for only 3 months, that means I have to file every 3 months. I mean, you're more than tripling the number of petitions that have to be filed for one person. That of course is going to create a backlog and a longer processing time. So probably not the best idea from a processing time standpoint to require all of these additional filings, but I'm sure they're enjoying the extra filing fees that they're getting with every single one of them. As far as premium, it should be available in February.
I
At
don't know
least that's
why
what
he
they
had an option of doing premium processing, because he filed his extension, even if it was an amendment plus extension, he filed in June, he had until September,
Yeah,
he could have.
upgraded.
There's one other rumor, Emily, is that is premium processing sure shot to get the RFA denial? Are there higher chances of RFA denial in premium processing than the normal processing?
Yeah, that's always the rumor, and I really don't agree with it. I really like premium processing. I always am of the opinion if the case is going to get an RFE, it's going to get an RFE whether you file in premium or regular. You just hear about it faster in premium, so you assume that it's the premium that caused the RFE or it's the premium that caused the denial. And I just really don't see that. We have very good success in premium processing. Yes, we do get RFEs, but we expect them. We would have expected them even if they were in regular processing. You usually know when you're going to get an RFE if you're an attorney who files a lot of H-1B petitions. There's some from time to time that you think are odd or not typical or shouldn't have got an RFE, but most of the time nowadays you can tell when you should expect one. And I don't think it's the premium processing that causes it at all.
Toshi from YouTube has this question. His I-140 is approved. He filed his adjustment of status. Before 180 days, is it recommended to change the employer? The answer is no. Please don't change before 180 days after you file the adjustment of status. If you do so, your 485 will be denied. You need to, and when you change the employer, don't forget to file the 485J supplement form. If you don't file the 485J supplement, that too after 180 days that you file the 485, you should file the J supplement. If you don't, they will deny your 485 application. So when you join the other company after 180 days, make sure that you file the 485J supplement with the new employer. Now I want to go to these main questions that are coming in Facebook, and there are many denials, Emily. And what is it? Motion to reconsider is better option? Is it when the H-1B denial comes in? Is it appeal? What are the probabilities that you have seen? Because the statistics say that only 3% chance of approval in the motion to reconsider and an appeal. What do you recommend your clients, or what do you recommend the audiences when they have a H-1B denial?
I think it obviously depends on a lot of factors. Number one, can we overcome the grounds of denial? It's going to be the first question I ask. Was the denial proper? Is there something that we could provide now that makes it a stronger case for the appeal to be successful? And another big factor is the type of case it is. If it is a cap subject H-1B that was denied, your only option is to wait till next year or file an appeal or MTR. So in those situations, I am much more likely to file an appeal and fight that case because I don't want the individual to have to wait an entire, really 18 months at this point to file in April, get it selected, wait for the approval before they can finally work in H-1B status. So those are the most likely case that I might file an appeal on. Other than that, as you mentioned, the chances of success when the appeal goes to the Administrative Appeals Office, the number of cases that actually get reversed and approved is only 3% for H-1Bs. So it is very likely that an appeal won't be successful. Now, we don't have those statistics for motion to reopen and motion to reconsider. There's a lot of kind of tricky things with these different options that you have. An appeal is automatically treated as a motion to reconsider or reopen first by the service center that issued the denial. And if the service center still thinks the petition should have been denied, then it goes on to the appeals office where they take a second look at it. That's where only 3% get overturned. But there are some situations where it can be overturned at the service center. A motion to reopen versus a motion to reconsider. The differences depend on whether you're submitting additional documents or not, or whether they're claiming that it was denied because you abandoned the petition because you didn't respond to a request for evidence on time. So there's just a lot of tricky things to understand in order to make that decision. I think that more and more you're likely to see companies going straight to federal court versus wasting time with the AAO when there's such a low chance of approval. There's a much higher chance of success when you sue the government in federal court over an arbitrary or capricious decision that they made on an H-1B petition.
Can you give the timeline with regards to motion to reopen or reconsider, and can you give the timeline on appeal once you file a motion to reopen or appeal?
So the appeal, the AAO processing time is generally about 6 months for an H-1B from the time the petition actually gets to the AAO. So remember, I said that first they'll treat it as a motion to reopen at the service center. So that takes about 60 days for the service center to review it, and then it goes to the AAO. You have to take into account the time it takes to transfer the file from the service center to Washington, D.C., and then plan on a good 6 months there, which is another reason why it sometimes might not even be worth it to file an appeal. You know, talking about these cap subject H-1Bs that are getting denied now. If you're filing an appeal now, you're not going to get a decision before April. So you're going to have to be, face the choice in March. Do you wait on the appeal and see if it's successful, or do you just refile in the next cap? And you can actually do both at the same time. If the cap petition actually is selected the second time around, you may have to choose and withdraw one or the other, but there's nothing stopping you from filing in the cap. But that's something to consider as well. The long processing time might make the appeal just not worth it. If it's a motion to reopen or motion to reconsider, as I've mentioned, it takes about 60 days for them to decide whether to reopen or whether to reconsider. And then once they make that decision, it still has to go through the actual looking at the case to make the decision. So when you file a motion to reopen, for example, you're asking them to reopen the case because there was something they weren't aware of or some document that wasn't available that is now, that now shows that the case should be approved. So first they're going to decide whether to reopen it. Once they make that decision, then it can be another several months before they actually issue the decision on the reopened case. Same thing for motion to reconsider. So neither of them are fast processes. If it's a very egregious denial, clear error, they tend to be much faster in reopening those. But if it's a borderline case, I would plan on a couple of months.
A question from Hariharan. If the person, he's on EB2, got his EB2 I-140 approved, and as we know that it's going to take ever for these people to get the green card on EB2, can I just enroll in a PhD program and then get the EB1 approval? It's not that easy what you think, that just because you get a PhD, you are going to get an EB1 approval. It's a very uphill battle there. There are a lot of different things that you need to prove to be an EB1. One is extraordinary ability, that's very tough to prove. The other option is that outstanding researcher. Normally you must be working in a research field in an area, and there must be other researchers in that particular organization. And the criteria to meet the requirement is not easy in those things. So it's not just you get a doctorate degree, you'll get an EB1. There are a lot of other criteria you need to look into. Before you take that great step of going and joining a doctorate degree, you may want to check with a lawyer to see if the objectives that you have in doing your doctorate degree can be achieved, and what are the probabilities for those things to be achieved. You might want to check. You don't want to waste all your energy and all those things and find out 10 years down the line or 7 years down the line that it did not meet all the requirements, so you're not eligible for EB1. So it's better to have a checkup right now itself.
Yashwant is asking, is an H1 amendment risky? Not in and of itself, but you do need to understand that amendment means they're going to look at everything all over again. You're not simply looking at what's changed and deciding whether the change is okay. They look at your education again. They're going to see if you're qualified for the position. They're going to look at the company again, look at the employer-employee relationship again. So specialty occupation. So it's practically like a new filing. So just because you've been approved once and you're just doing a simple amendment, there's really no such thing as a simple amendment. So yes, they can be denied, and they're not just automatically approved just because the underlying petition was approved before.
99 Globe has this question that he filed a H-1B transfer. Can he travel right now? no, while the H-1B transfer is pending, you cannot travel. The other question is that can you withdraw this application after you leave the country? I don't know whether you already started working with company B, which filed for the transfer. If it is, I would definitely want you to check with your lawyer before you take any travel plans. If you have not started working with company B, which filed for the transfer, yeah, you can travel on company A and then come back. And if you have a visa with company A, come back and then file the transfer again. Or good for lawyers to make more money on filing the H-1Bs. But if you are working with company B, that's going to complicate the whole situation. If you're not working with company B, yeah, you can withdraw the transfer, go to your home country, come back and file the transfer again. That's fine.
Surya has a question. His company is planning on filing his H1 in the April lottery, but he wants to know if he can travel in January beforehand. Is there an issue with coming in 60 days before filing? That is a good question. So there was a change to the Department of State interpretation where they said that if you're coming in one visa category and then you're planning on changing to some other type of visa within 60 days, that could be considered a misrepresentation. If you are, if what you said you were coming in for 60 days ago and now all of a sudden you've changed your mind and doing something different, that can be a problem. That being said, we were worried, we talked about this in January of this year and how it might impact the cap cases this year for those that were traveling right before April. And we raised some concern that there might be a problem with that. So far, we've not seen any issues with that. It's not something USCIS is really focusing on. It is a Department of State issue, not a USCIS issue. So as of now, I think travel is probably okay during that time, but you mentioned you're on your STEM OPT, so you have to make sure you can convince the officer at the port of entry that you're coming for the purpose of study, even though you've already completed your program, that you intend to leave when your OPT expires, even though you're planning on filing an H-1B. So that you may or may not be allowed to enter back in January to be able to file that H-1B. So take that decision very carefully.
The way this administration is going, I wouldn't take a risk of going, but as Emily has pointed out, that we did address this last year when we were filing, and we haven't seen any H-1Bs getting denied at this point of time for that reason, I would say. Can we change the status from H1 to F1 visa? One issue with the H-1B to F1 is that you have to maintain the status of the H-1B until your F1 is approved, which is taking anywhere between 8 months to 16 months. So if your H-1B is expiring, you may have to file a thing called bridge application, B2 bridge application, and you may have to file a couple of B2s before your F1 is adjudicated. So there are a lot of complications associated with it. If you guys are planning to do the transfer from H1 to F1 by yourself, don't. Please hire a lawyer to do it because it's very complicated. Now, back in olden days, it was very simple. It used to take 2 to 3 months. Things used to go through smoothly, but not anymore.
Anugna has a question about a nonprofit H-1B. Kind of what is that? So there are certain employers that are exempt from the H-1B quota. Being a nonprofit employer by itself is not enough to be exempt. So when you're exempt from the quota, that means that you can file the petition any time of year, regardless of whether the cap has been met or not. You don't have to go through the lottery in April. But again, not all nonprofits qualify. It's typically going to be an institution of higher education, so a university sponsoring you for the visa, or a nonprofit organization that's affiliated with the university, or a nonprofit research organization or government research organization. Those are the only employers that are cap exempt and allow you to file an H-1B at any time of year.
Nishita has a question from YouTube that his H-1B is being denied. He's in STEM extension. Can he travel on the STEM extension? The main thing that is that, as Emily has pointed out, make sure that you have the non-immigrant intent when you come back. But the other thing that I'm concerned about is that if your H-1B has been denied, is it just the H-1B or did they went in further and commented about the status issues? We have seen that in some of the H-1B denials, they said that you violated the F1 status. If they do that, you need to contact the lawyer immediately. But if there is no status denial, just the H-1B denial, we have never seen much problems for the STEM extension people going to their home country and coming at this point of time.
Okay, I had a question about prevailing wage processing times. And they're taking about 4 to 5 months right now for getting a prevailing wage determination for the perm process. And no, the employee does not have a way to check the status of that online. Only the employer can do that through their iCert account.
Vanilla has this question from the YouTube that she tried from H4 to F1 2 times in stamping. And then she got the rejection. Can she try again in December? I wouldn't recommend doing it. Here is the reason why your F1 is getting rejected, though, is that the Department of State, the consulate, does not believe that after you complete your education, you are going to go back to your home country. That is a major reason of denial for a lot of non-immigrant visas, including the F1 and the B2 visas. In your case, you're getting the H4 approvals without much problem there, because in the H4, even if you have intention to stay in United States permanently, that is not a bar in getting the H4. You already got 2 times rejection on F1. I won't try to do the F1 again. It's up to you if you want to try to do the change of status here in United States, but yeah, I won't try it because you might be construed that you're making a false application because you have already got 2 times rejected. You're trying again. I won't dare to do it if you already got 2 rejections.
Sorab has a question about, he has an H-1B filed in April, then filed a change of status to H-4 while that was pending, and now the H-1B change of status is approved. Great. Is it a problem that the H-4 change of status is still pending? Yes. If your H-4 change of status gets approved, that's going to take you out of H-1B status and put you in H-4 status where you're not allowed to work. So it's very important that you speak with an attorney that filed that H-4 change of status so they can withdraw it before it is approved so that you can continue in your H-1 status.
I'm going to go through quick questions from the YouTube, just going to the answers. The H-1 extension is pending. Can the spouse travel while the H-1 extension is pending? If the validity period of the H-4 is still there, she doesn't have any problem in traveling, and then she comes back. Once she comes back, she can apply for the H-4 extension. Absolutely, that's not a problem. Another question from the YouTube is, the amendment is pending right now. Can I travel? We recommend not to. Here is the reason. When you're coming back, are you telling you're working with the old client or the new client? If you're telling you're working with the old client, that's a lie. You should be denied entry into this country. If you're telling that you're going to work with the new client, that H-1B amendment is not approved, so there is a chance that you might be thrown out of the country. I won't recommend doing it at all.
Nilesh has a question about downgrading from EB2 to EB3. Can you file the EB3 I-140 in premium processing? The answer is generally going to be no if you're using the same labor certification because you have to wait for USCIS to pull that labor certification out of your old file and move it to your new file before they can adjudicate. So you won't be able to do premium. I would plan on an extra couple of months for that I-140 to be approved because of that time it takes to transfer everything, so probably at least 8 months.
Going to the questions immediately to YouTube. Hidayat has a question. I-140 is pending from March of 2018. Yeah, it's taking about 6 to 9 months nowadays to get adjudicated for the I-140. You have the provision of applying the premium processing. You can avail that opportunity of premium processing. Another question from Shiva is that if the amendment has been denied, does the base application is denied too, or no, the base application is still valid? You can go back and work with the old end client or the location with the similar job duties, or you can file one more amendment, or so the base application is not denied, it still is valid.
Kaushik has a question. Can I book my H-1B visa application appointment for stamping at a different consulate than the one listed on my I-129 approval or I-797 approval? Yes, you can. You can go to any consulate, even if a different consulate is mentioned on your approval notice.
Box H1B, I have a couple of questions from YouTube on those things. One is that if your H1B has been stamped in India before and you're going back within 1 year after the stamping has expired, you may be eligible for the Box. That means that you don't go for the direct interview. You make all the application, you drop in a box, and you'll get everything done. Now, however, that's not an assurance that you're not going to be interviewed, even though you're eligible for Box. We have seen a lot of people getting called for the interview and then getting the 221G. If you're eligible, yeah, it's good, but doesn't mean that you're assured to get the H-1B stamping.
We mentioned earlier that we're seeing an increase of denials of H-1B, and Purva's asking kind of what are the main reasons for that. One of the top reasons for denial is the position is not a specialty occupation. Another major reason is beneficiary qualifications. They feel that the degree is not related to the position. Employer-employee relationship when third-party placement is involved, or they're not able to confirm the details of the project. Maybe there wasn't an end client letter, or missing a contract or work order. Those are going to be the top reasons for denial that we're seeing right now.
I think so. A lot of questions, Emily. I don't know which ones it is. Can I do the day one CPT from the doctorate degree? I've done OPT and STEM extension and the master's degree. No, just because you're moving into higher degree, day one CPTs still are not something that we would recommend. We are trying to address as many questions as possible. Don't forget that we have a daily conference call. You can always go to rnlawgroup.com and you have a daily conference call that you can come and ask questions. And if we cannot address any of the questions, if you want to make an appointment with me, Emily, and any of our colleagues who are very good lawyers in our office, you can make an appointment with them too. Emily, any more questions for you?
Let's see here. Ooh, Jayansh has a good question. Where can we read more about immigration laws?
Huh?
Where can we read more about immigration laws? We have a lot of articles on rnlawgroup.com. There's years and years worth of articles. We try to post informational articles about different types of visa applications, as well as latest trends and updates, breaking news that are happening. You can also go to immigrationgirl.com and subscribe there. I post a lot about...
Who's Immigration Girl, Emily?
That's me.
Okay.
So I've been writing immigrationgirl.com, the blog, just to provide you with practical information that you can actually use in your daily life as dealing with the immigration laws. So you'll find a lot of good information there, and you can ask questions just like you can here on Facebook and YouTube.
And then we also have the podcast in Google and also in iTunes. We have a daily conference call, so you can even listen to when you are going somewhere. Just download those things and listen to those things too.
All right. Well, thank you all for joining us.
Thank
we'll
you
be
guys
back
for
next
coming
Tuesday.
in. Thank you guys.